Now, in the year of 2002, there was a case of Pradeep Kumar Biswas versus Indian Institute of Chemical Biology. Now, the Supreme Court said that the tests formulated in Ajay Hasia are not a rigid set of principles. The court held that cumulative effect of all the tests will be considered to find out whether the body is financially, functionally and administratively dominated by or under the control of government of India or government of state. So, the concept was little bit more widened in the year of 2002. Now, in the year of 2005, in the case of Zee Telefilms Limited versus Union of India, the Supreme Court excluded Board of Control for Cricket in India from the preview of Article 12. The court said that mere regulatory control, whether under statute or otherwise, did not make a body state. The court found that the board was not the creation of any statute. The government had no financial control over the board. Moreover, the state confers no monopoly status over Board of Cricket in the country. The court found that the government has no only regulatory control over the board and not administrative one. Therefore, the court held that board was not state under Article 12. However, the relief against BCCI is available in High Courts under Article 226. But it is very important to understand or to determine whether the BCCI should be made a state in future or not under Article 12 of the Indian Constitution. And the debate has been started nowadays that it should come within the purview of Right to Information Act 2005. So, this is the requirement of the modern welfare state that BCCI should be made a state. In the year of 2007, Lieutenant Governor of Delhi versus V.K. Sodhi, the issue of whether State Council of Education Research and Training is a state within the meaning of Article 12 of the Indian Constitution was raised. The Supreme Court found no governmental interference or control, either financially, functionally or administratively, in the working of the council. In the year of 2006, the case was Assam Small Scale Industrial Development Corporation versus JD Pharmaceuticals. A legislation of 1989 was enacted for promoting industries in the state of Assam, including small scale industries. The 1989 Act constituted a board for the purpose of monitoring supplies to various departments. The managing director of the corporation was a member of the board in terms of the provisions of the 1989 Act. The Supreme Court held that it was a statutory body and was a state within the meaning of Article 12 of the Indian Constitution. The contract by and between the parties being a statutory one, the corporation was required to act fairly and reasonably. However, all the above said statutory bodies, corporations, government companies and or public sector undertakings are not state within the meaning of Article 131 of the Indian Constitution. Now, Article 131 of the Indian Constitution, it provides original jurisdiction of the Supreme Court subject to the provisions of this Constitution. The Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the Government of India, one or more states, between the Government of India and any state, between two or more states. So, there are certain decisions which are saying that enlarged article saying that enlarged Article 12 is not applicable in case of Article 131 of the Indian Constitution. In the case of Tashi Delic Gaming Solutions Limited and another versus State of Karnataka, so case of 2006, the Supreme Court held that the enlarged definition of state under Article 12 would not extend to Article 131 of the Indian Constitution. The court says that it is also not in dispute that even a statutory corporation is not a state within the meaning of the said provision. In the case of Shrikant versus Vasantrao 2006 judgment, again the court held that the corporation or the other states instrumentalities are not state government for the purpose of section 9A read with section 7 of the Representation of the People Act 1951. In the case of state of Assam versus Barak Upatyake DU Karamchari 2009 judgment, the Supreme Court held that the fact that a corporate body or a cooperative society answers the definition of state does not make it the state government, nor will the employees of such a body become holders of civil posts or employees of the state government. Now, in the year of 2011, Indian Medical Association versus Union of India, the Supreme Court held that the rights of the non-minority education institutions to admit students of their choice, if exercised in full measure, that would be detrimental to the true nature of education, as an occupation damage the environment in which our students are taught the lessons of life and imparted knowledge, and further also damage their ability to learn, to deal with the diversity of India and gain access to knowledge of its problems, so that they can appreciate now how they can apply their formal knowledge in concrete social realities they will confront. There is a need to interpret state in case of imparting education. Imparting education is one of the very basic public function, and for this purpose there is a need to enlarge the scope of state. Now, since education is the most important function of public importance, every individual body or entity performing such public function should be considered as state action within the meaning of Article 12 of the Indian Constitution. Now, the liberal interpretation of state action is the only way to protect individuals' fundamental right to education in India. The National Commission to Review the Working of the Constitution 2002 had recommended that in Article 12 of the Indian Constitution, the following explanation should be added. The explanation was, this article, the expression other authorities shall include any person in relation to such as it functions which are of public nature. Now, there is a need to put some light on certain recent concerns. Nowadays, in the era of liberalization, globalization and privatization, the state is outsourcing its public functions to the private authorities, private entities and private individuals. Now, once they have outsourced their functions, the government would say that now we are not responsible towards your fundamental rights. So, it is very dangerous in future, because in the coming era we are dealing with the more private entities which are coming into picture, and they are dealing with our basic rights, basic fundamental rights. If we would go to enforce our fundamental rights, then we would be totally helpless to enforce our fundamental rights against the private individuals. So, where the private entities or the private individuals, if they are performing any public utility functions or imparting any public function, in that case they should come within the purview of Article 12 of the Indian Constitution, and they should be considered as state. For example, where a private employer terminated the services of his employee on some unreasonable grounds, where that employee would go? Definitely, if there is a reason, if one of the reason is that employee was homosexual, that is totally unreasonable, and whether he would be able to enforce his fundamental right against the private employer or not, this is the very prime issue. Similarly, the government's function of surveillance, it has again been outsourced to the private entities. The private bodies, private enterprises, they are conducting surveillance on their own, and maybe it may be used in future for the government function only. But while performing such surveillance things, they violate our basic fundamental rights, like right to privacy is there. Right to privacy is very important. Right to privacy is a thing in which we live our all private actions. Nobody can say that there is nothing to hide. Everybody has so many things to hide. Even if somebody is raising their children, if somebody is going to their work, if they are law abiding citizens, definitely still they have many things to hide. And the notion that we have nothing to hide, it's a very dangerous for other things, like it would be very dangerous effect upon the protection of whistleblowers. If somebody wants to disclose some important functions, I mean important files or important information of the government, in which government is violating our fundamental rights, or any other person is violating the things, or if there is some political opponent or political dissident, if he wants to disclose or wants to reveal certain basic things, in that case there is a need to protect that whistleblower. And if we say that we have nothing to hide, how it will have an impact upon his right? He would definitely, whenever he would disclose such things, or whenever he would be a political dissident or political opponent, the government would try to make a surveillance, or they will try to hire these private bodies to have a surveillance over that person, and will try to collect certain information which would distract the people's attention from the substantial issue. So this is very important. So there is a need to interpret the concept of state under Article 12 of the Indian Constitution in a wider sense. Finally, we should conclude this module. In this module we discussed the development of the concept of state, how that the United States and the United Kingdom, they have given nowadays a wider interpretation to their state action doctrine. And even in India, we have discussed various case laws in which the Honorable Supreme Court of India has endeavored and made a very strong efforts to widen the scope of Article 12 of the Indian Constitution, and it is very important. It is important in the modern era, where the government is outsourcing its public functions to the private entities, private bodies, private corporations, or the things like that. So in such circumstances, where they are performing the public functions, and in that performance our fundamental rights are at stake, there is a urgent need to interpret Article 12 of the Indian Constitution, that is state. And we have discussed in the last that how the things like government surveillance powers, or that have been again outsourced, and now that these private entities and private bodies and the social networking sites, they are collecting huge amount of information on us, and there is a chance that information can be misused in future. And for the protection of our right to privacy, there is a need to interpret Article 12 of the Indian Constitution, so that we could enforce our basic fundamental rights against these bodies also, against the social networking sites, or against the other private individuals who are dealing with our fundamental rights, or who are performing the public functions. So it is very important, and by this I conclude this thing. Thanks.